This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about why when you sue somebody, you must do so under your own name, and why a fraud defense is insufficient to allow an insured plaintiff to sue an insurer under a pseudonym. You just shouldn't ever have to hide your identity. Plaintiff sued State Farm under a pseudonym. The court subsequently issued an order requiring plaintiff to proceed using his own and actual name. Plaintiff appealed that order and seeks to stay the court's order while his appeal is pending. In James Doe v. State Farm General, the United States District Court for the Northern District of California on November 26, 2024, resolved the dispute. Plaintiff alleged State Farm improperly and in bad faith denied coverage for his claim involving a lost wristwatch that retails at approximately $30,300. He filed his complaint under the pseudonym James Doe, insisting a pseudonym was necessary to protect his privacy, his family, his reputation, and his livelihood because he has been struggling with mental illness. The court eventually rescinded its order permitting plaintiff to proceed anonymously. At a Zoom hearing, the court informed the plaintiff his actual name appeared on the Zoom screen. Although plaintiff had yet to file a motion to stay the court's order requiring him to proceed under his actual name, the court denied State Farm's motion as to breach of contract and wrongful policy cancellation claims. Jury trial is scheduled to commence in May of 2025. The court, analyzing the issues presented, noted that parties may use pseudonyms in the unusual case when a non-disclosure of the party's identity is necessary to protect a person from harassment, injury, ridicule, or personal embarrassment. Plaintiff based his claim for anonymity on two grounds. One, plaintiff argued anonymity is necessary because he has revealed highly sensitive and personal matters about himself, his mental illness, and his physical injuries in the course of the case. Yet plaintiff did not identify where in the record those highly sensitive matters are disclosed. Plaintiff has not sought to redact any portions of the filings, assuming anything in them may be concealed from the public, so plaintiff is unlikely to prevail on this theory. Second, plaintiff argues anonymity is necessary because the accusation of insurance fraud will ruin his reputation for honesty before a jury has passed judgment on his credibility and honesty at trial. Plaintiff states this case involves grave social stigmatization to plaintiff because he has been accused of committing or seeking to commit insurance fraud. The USDC noted that plaintiff showed, however, no reasonable probability that an insurer's material misrepresentation defense transforms a breach of contract claim into a matter of sensitive and highly personal nature. Here, plaintiff is seeking coverage for a lost wristwatch. If an accusation of insurance fraud were sufficiently stigmatizing to warrant anonymity, then plaintiffs could proceed anonymously virtually any time they challenge an insurer's denial of coverage on the basis of material misrepresentation. The Ninth Circuit's mandate requires that parties only use pseudonyms in an unusual case. Plaintiff claims irreparable injury, but failed to demonstrate he will be irreparably injured absent a stay. The injury plaintiff fears has already occurred to some extent by plaintiff's own doing. He appeared at a public hearing using his actual name. Further, in his recent summary judgment order, the court concluded there was a dispute of fact as to whether plaintiff intentionally concealed or misrepresented a material fact or a circumstance relating to his insurance, and at this point in this proceeding, there has been no finding of insurance fraud. Given that the plaintiff himself proceeded at a public hearing without taking steps to prevent the very disclosure he claims is so injurious, plaintiff has not met his burden on the irreparable injury factor. As summary judgment was denied on the breach of contract claim, the case is proceeding to trial. The public interest lies in transparent and public court proceedings, especially trials, and the court denied, therefore, plaintiff's motion to stay the order requiring plaintiff to proceed under his actual name. In my opinion, pursuing litigation under a pseudonym because the defendant insurer claimed the plaintiff attempted insurance fraud because his mental health and reputation would be harmed by the claim is simply insufficient to allow it. First, plaintiff chose to sue State Farm. He could protect his mental health and reputation by not suing. Second, he was willing to attend a Zoom hearing with his true name showing, thereby effectively waiving the claim of anonymity. It could easily be concluded that the plaintiff has sued under a pseudonym because he was embarrassed he was caught in an attempted fraud. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5 or 6 a week, as long as I don't get pneumonia again. And you will have access to the more than 4,900 blog postings. Please tell your friends and colleagues about this blog and the videos so that they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.